Hi. Welcome to the 7th episode of our talks about distribution agreements worldwide, dedicated to Italy. Our speaker today is Irena Grassi, our expert based in Bologna, interviewed by Roberto Luzzi Crivellini. The main topics discussed are the regulation of distribution agreements in Italy, important clauses in these agreements, main issues that tend to arise in distribution contracts, and how to manage conflicts in an effective manner. Make sure you follow Legalmondo on LinkedIn and YouTube to stay updated on the next episodes.
Hi, Irene. Welcome
Hi.
to our 7th episode of our distribution talks, where we discuss Italy. Hi.
Thank you very
And
much.
thanks for joining us. The first question normally is about regulations. So, how are distribution agreements regulated in Italy?
In general terms, distribution agreements are not regulated in Italy. So general rules on contract law applies. But there is an exception for car distribution, the automotive sector, which is partially regulated. There is a recent law of the end of last year, which introduced some mandatory rules for the protection, mainly for the protection of distributors. But apart from that, as I said, the general rules on contract law apply, which means that, for example, a contract which is concluded for an indefinite period of time can be terminated by each party with an appropriate notice. And if a court considers that notice not appropriate, can order the terminating party to pay damages, for example. Or the principle of good faith, both in negotiations and in the implementation of the contract. And violation of good faith may give rise also to damages. Then in general, antitrust rules, as far as, for example, exclusivity is concerned, or rules on post-contractual non-competition agreements, general rules on termination for breach of contract. In principle, courts in Italy consider the distributor as an independent entrepreneur, which takes the business risk. So there is no analogy with the agency law, as it happens in other European countries. So in principle, there is no indemnity for distributors, except, as I said before, for car dealers, which have right to a fair compensation, but that's an exception. So distributors are considered independent business people. There is a tendency in the case law to, which is not limited to distribution, but in general to vertical agreements, to protect the weak party of a relation. And so sometimes to grant damages whenever there is a excessive sacrifice of the weak party in a relation.
Okay, thank you. What are, based on your experience as a transactional lawyer and also a litigator on distribution matters, the main issues that tend to come up in distribution agreements? You mentioned, for instance, the termination notice, but what else? What should we be aware of when distributing or when negotiating a distribution agreement with an Italian counterparty?
In my experience, the most frequent issue is really all what happens around a termination. Because, as I said, in Italy, there is no termination indemnity for distributors, but nevertheless, when a distributor is terminated and they feel it is not fair, they claim damages for unfair termination. And there is a case law, for example, on the so-called abuse of right, when termination results in an unjustified sacrifice, as I said before, for the terminated party. This can be considered a breach of the obligation of good faith. And even though there was a notice was given, like contained the notice as regulated in the contract, courts may consider termination unfair and order the terminating party to pay damages. And also there is a law on the abuse of economic dependence, which protects also the weak party in a vertical relation. And also under this law, termination can be considered arbitrary and unfair and give rise again to damages. And damages may include loss of profit for the longer expected duration of the contract, or costs for investments, which were required to the distributor and could not be redeployed. So this is, in my experience, the most frequent cases of litigation. So it may be important to regulate termination in an appropriate way. So give an appropriate termination notice, appropriate related to the kind of contract, the type of investments which are required, and regulate, for example, all aspects which are connected with termination, like the stock. The repurchase of the stock, for example, could be, if it is regulated in the contract, it is easier then to find a settlement with the distributor at the moment of termination, and be sure that there are no disputes on the value of the stock or on the obligation to repurchase it, because the stock can be a cost for the distributor, which cannot sell it anymore. Other aspects to consider also related to the termination, all the obligations related to the name, the use of the name, the signs of the distributor, of the supplier, or the principal. Also, this should be duly regulated in the contract so that there are no disputes or less disputes in the end.
Okay, thank you. That's I can confirm that's something that termination notice, and what happens with the stock of products is something that tends to come up frequently, also in my experience. So yes, that should, we should keep that in mind and give the appropriate attention to that clause. In my experience, also there's an issue of payments within the termination period, and so maybe it's important to keep in mind that we don't want, ideally, that there are orders with a payment term that lapses after the contract is already terminated, and so to consider whether we should already agree on special rules for the payments and the value of orders and so on and so forth during that special time of the life of the contract, which is termination, when one party has already told the other party that it's going to finish the contract. So yeah, I think that's
absolutely.
Do you have any other tip, Irene, based on your experience, that you would recommend keeping in mind for those who are negotiating an agreement with an Italian distributor?
Well, one very basic tip would be to draft a contract, to consider drafting a contract in all these gray areas where there is a continuous supply, but it's not clear whether it is only a sale and purchase supply or a distribution. That is, that when there are obligation of promotion from on the side of the distributor, or for example, there is an exclusivity, there may be a de facto exclusivity, but the parties then, for example, the supplier decides to appoint a distributor or an agent, and there is a de facto distributor which claims termination notice, for example, but the supplier considers it's not, it was just orders, sell and purchase, and so he has no right to anything. So it's always better to regulate this situation and not let them go for years and years and discover in the end that there was an issue. Also, because if there is in fact, it is recognized as a distribution relation and international distribution, and there is no contract, there may be issues also on competent jurisdiction, because if it's not regulated, as you know, and you certainly know in your experience too, there may be trouble, because if it's sale contracts or distribution contract, it makes a difference.
Absolutely. Going to Irene, dispute resolution. So normally, how do you recommend your clients to regulate dispute resolution, and what are the methods that you would recommend, again, based on your experience, for those who are negotiating an agreement with an Italian counterparty?
My answer is it depends. I wouldn't say there is a rule. So it depends on the contract, on the type of goods, on the dimension of the distributor, on the market. So in some contracts, mediation, for example, could be a solution.
Yeah.
Not always, but in some contracts it is appropriate. What is to consider is that in Italy, due to a very recent reform, which will enter into force next month, for some types of contract which are very close to distribution, mediation will be mandatory and as a precondition for a judicial claim. That's for franchising, for supply, continuous supply contract, somministrazione, which is continuous supply, which can be very close to distribution. So it may be wise to regulate mediation in the contract as a precondition before judicial claim. Then arbitration. Arbitration is appropriate to some kinds of contract. Arbitration is in general quicker. It grants confidentiality, but it is expensive, so it's not always appropriate. If you decide for arbitration, I would always recommend regulated arbitration of a chamber of commerce, for example, or other institutions, specialized institution, because you can have, you can foresee the costs, you can foresee the procedure and have more control on the procedure, because arbitration, according to the Italian civil procedure code, is very much in the hands of the arbitrators. So it gives less certainty. So it's always better, in my experience, to choose a regulated arbitration. And then judicial claims are not so bad in Italy. Not at all. Judges are always, well, not always, but in most cases, well prepared, and the case law is rather easily. It's possible to find case law in and doctrine. So it is not so bad, but it depends. There are situations where it is appropriate and the situation where it is not.
Agreed. And I would add that the myth of the Italian torpedo and the Italian judicial system being subpar is not really, I would say, accurate. It really depends on where you might end up litigating. So one double check you want to do is on the court that you might appoint as an exclusive venue for jurisdiction. If it's Bologna, if it's Verona or Milano, for instance, or Torino, those are all excellent courts, rather, I would say, fast and competent. And for arbitration, totally agree. Maybe we can provide in this episode's notes the link, for instance, to the Chamber of Arbitration of Milano, which is by far, I would say, the most known for international contracts, and the chamber which has the more substantial expertise in such matters. Thank you very much, Irene. That was a good chat. We can provide in the notes of the episode a link to the practical guide on distribution agreements, which was done by Legalmondo members, and the link to your bio on our website for those who would like to reach out and know more. Thanks a lot, and I'll see you next time.